My name is Debra Nance. I'm a candidate for Judge of the 46th District Court. Many of you know me. If you live in Southfield, Lathrop, Beverly Hills, Bingham Farms, and Franklin Village, I was actually on your ballot November 2010. I did rather well in my first run for public office, garnering 44% of the vote. I came 6.1% of winning. But as many of you know, you must often do this more than once when you're serious about serving the community, and I am very serious about serving the community. My background, I am a civil litigator. I practice civil litigation, probate litigation, family law litigation, adoption litigation. I love everything about the courtroom, and that's exactly why I'm running to be your 46th District Court judge. I'm running on a platform, three primary issues, and I'm running very, very hard. Hopefully you've seen my signs out throughout the community, or you've seen my literature. I've actually knocked on your door to introduce myself. But my platform, first of all, is one of judicial integrity. Second, one of creative options, creative sentencing options to reduce jail overcrowding. And number three is the sharing of judicial resources in Oakland County in order to keep our county fiscally strong. But I've been asked today to talk about three primary questions that have been given to me, and I'll address those. The first of which is, and I'll read it, what factors would you consider in deciding what sentence to hand down in a criminal case? And because I'm an advocate of creative sentencing, let me share with you a few of the issues that I take a look at. There's a lot of information that's given to the judge that would be given to me as a judge in what is called a pre-sentencing report. One of the first and primary issues is a full, detailed description of the criminal offense. That's very important that the judge understand, again, exactly what has happened in this matter. The second would be the sentencing guidelines. It's very important that the judge, again, review in very good detail exactly what the parameters are of the sentence that can be prescribed in this particular offense. The third, but probably one of the more important for me, would be what is called a victim's impact statement. It's going to be very important to me to understand exactly how this crime or this offense has impacted the victim. How does the victim live with the aftermath of this crime that's been committed against them on a daily basis, and what has it meant in their lives? I'm also going to be very interested, however, in the impact that this crime has had on the victim's family members, the victim's significant others, and those around him, because as we all know, sometimes these crimes don't just happen to one individual. They can happen to an entire family, or in some cases an entire community. So I'm going to take a very close look at that. I'm going to look at the prosecutor's statement because I want to understand from a prosecutorial standpoint how the prosecutor sees this offense. I'm also going to look at very thoroughly the probation department's view of this offense and the background and history of the offender and what type of a sentence the probation department has recommended to the court. But then I'm going to take a look at the defendant. I'm going to look at the defendant and try to understand as best I can the defendant's criminal history, if there is a history. If not, this could be a first offense. I'm going to look at the defendant's social background. And what I mean by that, I want to understand their educational background. I want to know their marital history, if any. I want to know their medical history, if there is a medical history. I want to know their educational background. And what I'm looking for there is a good understanding of whether this individual is prone to repeating this offense. And I also want to understand what their connections to the community are, because that will tell me whether they have a support network that will assist them in not becoming a repeat offender. I think that all of this information will help me to fashion a sentence that is appropriate, a sentence that does the appropriate amount of punishment, if punishment is necessary for that particular offense. I'm going to fashion a sentence that gives the appropriate amount of rehabilitation if the defendant can be rehabilitated, but I'm going to fashion a sentence that is appropriate for the situation based upon a myriad of different factors. So those are some of the issues that I would look at to answer that question. The second question that's been asked of me: if you observe a party in your courtroom being poorly represented by counsel, how would you address the situation? I would start, first of all, and I want the public to understand that the judge in the courtroom is the judicial officer. And the judicial officer in the courtroom is responsible for maintaining and ensuring the constitutional rights of every party in the courtroom. And one of the issues that can arise if the defendant is not being adequately or is being poorly represented is that the defendant may then have an appeal based upon what is called ineffective assistance of counsel. I do not want to see a situation in my courtroom that, due to poor or shoddy representation by an attorney, a criminal who deserves the sentence that has been meted out now has the right to an appeal because he was not given proper representation. And proper and competent representation is that defendant's constitutional right. I'm going to make sure that that defendant gets his constitutional right the first time, so that any sentence that is imposed is a sentence that hopefully will stand. So I think that's extremely important. I'm going to have a private conversation initially with that attorney. We're going to have a sidebar. I'm going to be very open and candid and honest with that attorney regarding my perception of their representation. If that short conversation is not enough to address the problem, I'm going to ask for an adjournment, and we're going to have a more serious conversation in my chambers, because again, I have a duty as a judicial officer to make sure that all of the constitutional rights have been maintained. And that means up to and including reporting this individual to the bar, should that become necessary. That attorney has several options, however. The attorney can more adequately prepare their case. The attorney has an opportunity and a duty as well to bring in co-counsel to assist the attorney if there is the remote possibility that the attorney is not competent to handle that case. So again, I think that's a situation that has to be addressed, and it has to be addressed immediately, and I'd be very, very willing to do so. The next question that I've been asked to address, I'll read it. Under what circumstances, if any, would you feel obligated to disclose to opposing counsel that a lawyer appearing before you has donated to your election campaign? Again, a very interesting question, and the public may not know, but please let me share with you that the Michigan Campaign Finance Act has a very strict regulation that imposes full disclosure on all judicial donations. And what that actually means is, from the time that a judicial donation is made, there are reporting deadlines. And when that occurs, the judicial campaign must report to the campaign finance department and to the public exactly who has donated to their campaign, the amount of the donation, and a myriad of details regarding the individual who's donated. So attorneys who are donating to a judge's campaign, hopefully because they simply want to assist good judges in remaining on the bench, or to assist good attorneys who seek to aspire to the bench, that information is already disclosed to the public, and it is disclosed to the public on a very regular basis. So in response to this question, because that information is made available to the attorney prior to their coming before me, and is actually made available to any member of the public as well as the defendant, there would then be no need to disclose to an attorney appearing before me that opposing counsel has made a campaign contribution. I would also suggest that the question appears to infer that there may be some conflict of interest, and I would definitely state to you as the voting public that in my courtroom there will be no conflict of interest. And should there even be a remote possibility of a conflict of interest, that conflict would be fully disclosed, not just to opposing counsel, but to all parties in that particular matter, because a judge also has the duty to maintain judicial integrity and to make sure that there is no appearance, and I use that word, to make sure that there is no appearance of impropriety. And I would be the first person as your 46th District Judge to make sure that in any of my cases that there is never the appearance of impropriety. And should there even be remotely a need to disclose any information, that information will be disclosed to all parties in that particular matter. I want to end by once again stating that I am happy to be a candidate in this race. I hope to have your support and your vote. I've received a number of very, very important endorsements, those that I'm very, very proud and pleased to have. But the most important endorsement that I can have is your vote on August 7th. I want to share with you in closing my pledge to you. I have developed what I call a pledge of judicial integrity. A judicial candidate cannot make campaign promises. I don't consider myself to be a politician. I am interested only in the judiciary. So my pledge of judicial service says that I believe that I am the right candidate and the right person to select for this position at this time. I have litigated, mediated, or trained in every aspect of the district court. I cannot make any promises to you, but what I will pledge is that I have the strength and conviction to render the sentences that will keep our community safe. That's very, very important to me. That I have the empathy to exercise compassionate judgment when appropriate, and that I have the wisdom and knowledge to know the difference. Once again, my name is Debra Nance. I ask for your support, your vote on August 7th. Thank you. Thank you.